Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina's hearing in docket number 2020-264-E and 2020-265-E. Before we get started, there's some preliminary issues I need to address. Anyone who makes corrections from the stand needs to file a corrected copy or a errata sheet. So we had that happen on several occasions, so we need that corrected copy filed or an errata sheet. Second, the commission would like to recall witness Bradley Harris. Applicant, is he available?
We will certainly attempt to track him down. I know he had some travel this morning, but I will track him down.
All right, thank you, Attorney Smith. All right, roll call. Here in the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Commissioner or Chairman Williams. Joining us virtually, we have Commissioners Irvin, Williams, Thomas, and Powers. I believe our next witness is a witness for Southern Alliance for Clean Energy, South Carolina Coastal Conservation League, and Upstate Forever. Are you ready to call your witness?
Yes, Mr. Chairman, this is Kate Mixon, and we are ready to proceed.
All right, Attorney Mixon, please proceed.
Thank you. South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever call Edward Finley to the stand.
Mr. Finley, please take the witness stand and pause to be sworn by our court reporter.
Very well.
Mr. Finley, if you would raise your right hand, please. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I so solemnly affirm.
Thank you.
Will you please state your name for the record?
My name is Edward Finley.
And by whom are you employed and in what capacity?
I am currently an attorney at law in private practice in Raleigh, North Carolina.
Thank you. And Mr. Finley, did you cause to be pre-filed in these dockets on February 22nd, 2021? Rebuttal testimony consisting of 21 pages?
I did.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
No, Ms. Mixon.
Thank you. If the questions put to you in your testimony were asked of you at the hearing today, would your answers be the same?
They would.
Mr. Chairman, I would move to have Mr. Finley's pre-filed rebuttal testimony entered into the record as though given orally from the stand.
Mr. Finley's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you. And Mr. Chairman, we are going to present the summary of Mr. Finley's rebuttal testimony in question and answer format. Mr. Finley, could you please summarize your educational background and experience for the record?
Yes, ma'am. From 1974 through 2007, I practiced law in Raleigh, concentrating in a public utility regulatory practice before state and federal regulatory commissions and state and federal courts. From 2007 through 2019, I served as chair of the North Carolina Utilities Commission. While on the commission, I served, among other positions, as vice chair of NARUC and as chair of the NARUC Electricity Committee.
What is the purpose of your rebuttal testimony?
My rebuttal testimony responds to ORS's testimony opposing the Solar Choice program proposed by Duke and supported by the parties to the settlement agreement in this proceeding. Particularly, I provide general rate-making principles that can inform the Commission's decision in this proceeding. I critique ORS's overly narrow reading of Act 62 and its improper disregard for Duke's Commission-approved cost of service study. I discuss the benefits of the type of shareholder collaboration that resulted in the settlement agreement in this proceeding.
How can generally applicable rate-making principles inform the Commission's decision in this proceeding?
Rate-making, by its very nature, is an inexact science that requires balancing of complex interests. Chapter 62 highlights those interests the General Assembly wants the Commission to consider. Those interests include aligning customers' incentives with reductions in utility system costs. They include maintaining the solar market in the state. They include eliminating potential cost shift to non-solar customers to the greatest extent practicable, while ensuring access to rooftop solar customers. In my view, the phrase, to the greatest extent practicable, provides the Commission sufficient latitude to appropriately balance these potentially conflicting goals. However, all of these interests must be afforded weight. Contrary to the ORS's position, the Act does not require zero cost shifts.
Mr. Finley, are you familiar with the concept of cost shift from your experience in rate making?
Yes, ma'am. While the term cost shift is not defined in Act 62, it appears that the legislature had in mind the concept of subsidization, which is also a loosely defined concept in rate making, but generally the legal concept behind avoiding subsidization is one of avoiding undue discrimination. The operative word is the phrase undue. It is important to note that it is impossible to eliminate all subsidization of cost shifts in rate making. Rates are not designed for individual customers, but rather with broader rate classes in mind.
Is ORS's focus on eliminating cost shift consistent with the general rate making principles you just discussed, or with Act 62?
No, ma'am, not in my opinion. Any supposed cost shift from solar to non-solar customers is just one factor the Commission is directed to consider. Moreover, ORS's position appears to rely on an incorrect assumption that rate design is a zero-sum game. The ORS position is that a rate is good, that if a rate is good for solar customers, there must be an associated cost for non-solar customers. That is an incorrect assumption. It ignores the ways in which the Solar Choice Program is specifically designed to maximize the benefits solar customers provide to the utility system. These benefits significantly reduce or eliminate utility costs and therefore cost shift to non-solar customers.
What are some of the benefits that solar customers provide to non-solar customers on a utility system?
Some benefits of customer-owned generation are shared by the entire body of customers. For instance, rooftop solar can replace or defer the need for additional generation resources. Rooftop solar can reduce greenhouse gas emissions and other pollutants. Rooftop solar can avoid transmission and distribution costs. When paired with time of use rates, net metering customers can reduce consumption on peak, lowering demand and reducing costs for all customers.
Does Duke's proposed solar choice tariff minimize or eliminate cost shift to the greatest extent practicable?
In my opinion, yes, it does. Duke witnesses presented two measurements of cost shifts. One, under the marginal cost measure, it shows a significant reduction in cost shift. And two, under the fully distributed or embedded measure, solar customers may actually be subsidizing non-solar customers. In short, the proposed program is a win-win for solar and non-solar customers alike. The proposed program complies with the directive to eliminate cost shift to the greatest extent practicable.
Does the proposed solar choice program adequately balance all of the factors in Act 62?
Yes. The Solar Source Program is the only proposal put forward in this proceeding that seeks to balance all the factors in Act 62 that Act 62 directs the Commission to consider, and it does so well. The proposed program uses time of use rates to align solar customer incentives with reductions in utility system costs. The program ensures that the solar market will remain viable in Duke's territory. The solar industry's support of the settlement is evidence of this. The program still allows customers to save money on their bills by installing rooftop solar. The program significantly reduces or eliminates cost shift to non-solar customers. It accomplishes this in part by utilizing a minimum bill to ensure customer generators are contributing their fair share of costs each month.
How do you respond to ORS's argument that Duke should have used a different cost of service methodology in this proceeding?
I disagree. In my opinion, ORS's argument that Duke should have used a different cost of service study here is not based on any valid rate-making concept. Setting the appropriate cost allocation method may be one of the most subjective issues to determine in a general rate case. ORS's opinion that Duke's use of summer coincident peak is incorrect or flawed is not a valid opinion in this context. The question is whether Duke's use of summer coincident peak is reasonable. The Commission, with ORS's agreement, already decided that summer coincident peak is reasonable in the most recent general rate cases.
What would the result be if the Commission were to follow ORS's recommendation in this proceeding?
If the Commission were to follow ORS's recommendation and set rates for rooftop solar customers on the basis of a winter peak, an anomalous result would follow. Rates for one subclass of residential customers would have rates established outside of a general rate case. Rates would be set on the basis of a different cost of service method that the rest of residential customers and all other customer classes. This is unwise. In my view, the company is correct in basing its cost of service study in this case on the same cost of service allocation method approved in the last general rate cases and currently is reflected in rates. Otherwise, cost recovery will be shifted inappropriately or cost will not be recovered.
Lastly, Mr. Finley, what is your perspective on the benefits of a stakeholder process leading to settlement, as was the case for the agreement in this proceeding?
Based on my 46 years of experience as a regulatory attorney and as a commissioner, my opinion is that PUCs are often well advised to encourage parties to enter into stipulations where possible. If a commission finds that a stipulation is in the public interest and meets the regulatory objectives, there is good reason to approve those settlements. Settlements can substantially reduce the time needed to reach resolution, reduce litigation expenses, many of which would otherwise be borne by ratepayers, save time, and result in well-crafted commission orders that are less likely to be appealed or to be reversed on appeal. In my opinion, the process leading to the stipulation in this proceeding has resolved the issues in a very productive way. The agreement resolves differences of opinion, addresses the mandate of Act 62, and provides the Commission with a resolution that, should the Commission accept it, will benefit customers, solar customers, and the utility in alignment with the goals set forth by the General Assembly.
Does that conclude the summary of your testimony?
Yes, Ms. Nicholson, it does.
Thank you. Mr. Chairman, the witness is now available for cross-examination and questions from the Commission.
North Carolina Sustainable Energy Association.
Thank you, Mr. Chairman. Peter Ledford on behalf of NCSEA. We do not have any cross for this witness.
Solar Energy Industries Association.
Thank you, Mr. Chairman. Jeff Kirkendall on behalf of Solar Energy Industries Association. We do not have any cross for this witness.
Vote Solar.
Thank you, Mr. Chairman. Beth Durant for Vote Solar. No questions for this witness.
Alder Energy Systems, LLC.
Taylor Spear for Alder Energy. No questions. Thank you, Mr. Chairman.
Office of Regulatory Staff.
Thank you, Mr. Chairman. ORS has no questions for this witness.
Applicant.
Applicant has no questions for this witness.
Commissioners.
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Finley, just a couple things. Obviously you've been able to read the testimony, and I don't know whether you've been in a position to watch all the testimony this week, but you've read the written things that have been presented, have you not?
I've read most of them, and I have participated by listening to the testimony offered thus far in the case.
And as is often the case, it seems when we're dealing with it, every level of testimony seems to get a little more contentious. I gather from your testimony that the goals and requirements of Act 62, I think by some of the testimony, we're led to believe they're not compatible. Are they not compatible to lower cost shift and to provide incentive for solar development?
They can be made compatible in my view. There are some positions of the act that are hard to reconcile to some extent, but I think they are compatible, and I think the stipulation that has been proposed for you balances the competing interest in a fashion that complies with the act.
And with your tremendous amount of experience, do you think environmental factors should carry some weight too?
I think in reading the act, the provisions of the act, it's a requirement that environmental considerations play a role in the decision that you reach in interpreting the act.
Okay. And now, off topic, you've been in Raleigh for a long time, have you not?
I have, yes, sir.
Do you know my good friend Ben Thompson with the Wyrick firm?
I know him by reputation, yes, sir.
Okay. I just thought if you did, tell him hello.
I'll certainly do that. Commissioner Powers, thank you.
That's all I have.
Thank you, Commissioner Powers.
Mr. Chairman.
Vice Chair Belzer.
Thank you. Good morning, Chairman Finley.
Good morning, Commissioner Belzer.
Chairman Finley, are you familiar with when the public service was restructured in 2005 and the Office of Regulatory Staff was created?
Generally familiar with it. We went through a similar thing in North Carolina in 1977, so generally familiar.
Well, have you read the testimony of the ORS witnesses, particularly witness lawyer?
I have read that early on. I spent more attention reading witness Horry's testimony.
All right, so I certainly understand that. ORS is charged by statute with representing the Public Service Commission, the public interest before the commission. And in the statute that charges that ORS with representing the public interest is defined. Are you aware of that?
I was generally aware of it. I'm aware of it after listening to the testimony thus far in this case.
Well, and to the extent that that definition charges and directs ORS with regard to its responsibilities regarding representing the public interest, I noted in your testimony and in your summary that you use the term public interest with regard to I think you said the stipulation satisfies the public interest and the statutory obligations of Act 62. Is that a correct summary?
It is, yes, ma'am.
Is there in utility regulation a broad tenet known as the public interest?
There certainly is, yes, ma'am.
And could you describe that or explain that to us, please?
Yes, ma'am. The regulators are responsible for ensuring the public interest in the decisions that they render. Now, in my opinion, that has both a short-term viewpoint and a long-term viewpoint. And I think to do it correctly, a lot of emphasis must be placed on the long-term viewpoint of what is good for the using and consuming public. The using and consuming public's interest must be protected. That's what the regulator does. The public utility, for the most part, has a monopoly, and it needs to be carefully regulated. But its interest and the interest of its stockholders have to be recognized too. That is another facet of protecting the public interest, because you need strong, well-managed, well-financed public utilities. So it is a broad spectrum of interest that must be protected, and the ultimate people who do that are you folks who are on the commission, and the public, the interests like the ORS and the public staff in North Carolina play a very important role in that. Sometimes interest of some of the customer classes are less well represented in general rate cases, for example, than the residential class is. And so oftentimes it is my experience that the ORS and the public staff in North Carolina will pay particular attention ensuring that the residential customers and those limited means, their interests are protected in the proceedings.
Thank you. Appreciate your testimony today. Mr. Chairman, that's all I have.
Chairman Williams.
Commissioner Caston.
Good morning, Mr. Findley.
Good morning, Commissioner Caston.
So in your opinion, you believe the stipulated solar choice tariff that DEC and DEP, the Duke companies, and your clients support the long-term renewable goals?
I think they do support the renewable goals and recognize interests of the state in general and the customers in general of the two companies. Yes, sir.
Do you believe that there is a cost shift?
I believe, based on my years of experience, that a cost shift in a proceeding such as this is difficult to measure. I have read carefully the testimony of the companies, Huber and Harris, and I believe that the measures that they use are the best measures for you to recognize in this case, and that to the extent that there are cost shifts, they are minimal and comply with the act.
If I didn't know better, I'd think you were an attorney.
Well, I am an attorney, for better or for worse. I've been called a lot worse things, but I am an attorney, yes, sir.
I know, and good job too, by the way, and I've heard good things about you.
Thank you.
You also mentioned rates are designed, I'm paraphrasing, rates are designed for the broader rate classes, not individual customers.
Correct.
Do you, in your opinion, believe that this stipulation or this agreement eliminates any cost shift to the non-participating customers?
To the maximum extent possible, I do believe so. You've asked in the context of this case some very interesting questions about who in the negotiations protected the non-solar generators and the general body of customers, the ones who can't pay and that type of thing. I will tell you that based on my experience with net metering tariffs over the years, the dispute usually has been between the public utility and the renewable generating class. And you heard Witness Barnes of NCSEA tell you a lot of the things that he didn't really like about this stipulation in support of the MOU and the bring your own, whatever that thing is, thermostat program in the MOU. And so there are things in there that the renewable folks do not like. This improves the situation, in my opinion, from the non-generators. And so somebody in those negotiations was looking after the interests of the generating people, the solar generating people. And you need to, in my opinion, look at the text of the settlement and the negotiation, and in my view, interests other than those of the renewable generating class are well protected. And I got to believe that based on what I know of the past experience, that the Duke companies were advocating those interests in this negotiation process.
So from all that, you believe that it is in the best interest of all non-participating, non-solar customers also, correct?
Yes, sir. I do believe that. Yes, sir.
I don't know how it would be done. We had that question or discussion with Mr. Huber yesterday. That I guess, at least from my perspective, if there was some signature on that stipulation that somehow included maybe more clearly or definitively some of those non-participating customer groups some way, and I don't have the answer for that. It would be more comforting to me, but that said, in your opinion, you believe that they've been looked after in this stipulation?
I do believe so. I believe the stipulation and the proposal that is before you and with the companies and the other people who signed the stipulation asked you to approve, looked after those interests. And I will indicate to you that the folks that I represent here, the South Carolina Coastal Conservation League, the Southern Alliance for Clean Energy and Upstate Forever, includes customers other than those who have solar facilities on their premises.
Thank you, Mr. Finney.
Thank you, Commissioner Castor.
Mr. Chairman, this is Commissioner Thomas.
Commissioner Thomas, you have the floor, sir.
Thank you. Mr. Finley, can you hear me okay?
Yes, I can.
Very good. I can hear you just fine. Did you by chance hear any of the interchange late yesterday afternoon between Mr. Huber and myself?
I did. I was listening.
Okay. And so, in my opinion, there will be new revenue generated as a result of this agreement between the parties. And do you agree with that?
There will be additional revenues because some of the customers, perhaps 12,000 of them, will have an increased rate they've got to pay. I think the question will be whether that is a net increase in revenues or not, or whether it will help recover costs that the companies are already incurring or not, and in what extent. I don't know the answer to that. It could be that there are net revenues that are increased. I don't know the answer to that.
Okay. And I guess part of my concern is that we are changing the rates on a small group of customers between rate cases, which is generally not something that's a good thing to do. Would you agree with that?
I would agree with that.
And part of the reason for changing those rates, again, in theory, is to help reduce that cost shift. Whether there is a cost shift or not, people like to argue about it. But for purposes of our discussion, let's assume that there is a cost shift and that the reason for making this change outside of a rate case period is basically to try to help reduce that cost shift. Do you agree with that?
Okay, I will go with you there.
Okay. So all I'm trying to do is make sure that the additional revenue is used for the intended purpose, which I think comes back to the greatest extent practicable that we've been talking about. It just should just go into a pot to be dealt with in the future in a rate case and see how it shakes out then. Mm-hmm. Do you see a problem with that?
Well, if you got a few minutes, I'll try to address that question. Okay. As you identified, what we've got here is a change in a rate schedule in between rate cases, and what I refer to that as out of period adjustments. That usually, as you indicated, does not happen. That's a bad idea. And sometimes you will have a new customer, a new group of customers perhaps come online, like a data center or an automobile manufacturing plant, where you've got to establish a new rate. That's a brand new rate. And you try to do that by being fair to the rest of the customers, that new customer or new customer class, the rates are established that allow it to the company to receive the cost of service to serve them, but no more. You've got a problem when you start adjusting rates in between rate cases with the issue of single issue rate making, as you sort of identified. And you've also identified a problem of if if you adjust rates in between rate cases, you're supposed to lose the benefit of that when you get to the next rate case. I think that's the concern that you're worried about. Single issue rate making. And so what you do, you can, as you alluded to yesterday, you can create a regulatory asset liability in the appropriate circumstance. And that should be done rarely. And it is done rarely. It is done, for example, when you have extraordinary storm costs. It is done on occasion when the utility will include in its rates or when it will put online a major plant. One of the issues that, I hate to mention this, but one of the issues that have resulted in asset liabilities in the past have been coal ash remediation costs. And in my understanding, what you do, because it's rare and unusual, you usually look at two tests to determine whether or not to create a regulatory asset liability. You look at is it really an extraordinary, unanticipated, major change? Usually it's a cost, as I mentioned before. It could be, I suppose, an increase in revenues, but is it unusual and extraordinary? And since that we're in between general rate cases, you look at what is the utility actually earning at the time these changes occur. The utilities file surveillance reports that show you the extent to which their earnings as we proceed through time are in excess or below their authorized rate of return. And in prong 2 of the two-part test, when we're confronted with the opportunity to create a regulatory asset or liability, you look at to the extent this unusual event will increase the earnings, the earned return, up to or above the authorized rate of return. And if it doesn't, or if it you look at that to determine whether it's appropriate to create look at that comparison to create the regulatory asset liability. And if you do, the commission must make that decision, and then it will make a deferral, order the utilities to defer that, bring them into the next general rate case, and then you can look at that, and to the extent that you believe that there have been revenues collected between the time these rates are changed and the past year in the next general rate case, you can recognize those and you don't run afoul of the issue of retroactive rate making and single issue rate making. Now, that's a long answer, but my understanding is that's the principles that are typically employed and that would justify creating a regulatory asset liability here.
Okay. And I guess to make sum that up a little bit, then having you thought through that the way you just did, and helped me think through it as well, I appreciate that. So, given all of the factors above, do you believe that this is worth considering setting up that regulatory asset liability account with regard to this change?
Well, it would be worthwhile to look at the facts, look at the extent to which the revenues, net revenues exist, to look at the authorized return, look at the earned return, make a determination of whether this change for 12,000 customers out of 760,000 customers meets the threshold of an extraordinary item, and it would take an analysis. I don't think you have the facts before you right now, but that wouldn't prevent you, should you choose to do so, to take a look at it.
Okay. All right. I appreciate that. I think that's all I have. Thank you.
Thank you, Commissioner Thomas.
Thank you.
Any more questions for this witness?
Mr. Chairman.
Commissioner Irvin, you have the floor, sir.
Thank you, Mr. Chairman. Chairman Finley, welcome to South Carolina.
Thank you, Commissioner Irvin. It's nice to be here.
I've got a lot of cousins up in North Carolina around the Morganton area.
Yeah, I think I know some of them. In fact, I served with one of them on the commission.
Yes, sir. I appreciate your explanation of the issue that Commissioner Thomas brought up, and I want to follow up on that just for a minute. One way to avoid that lengthy analysis, the two-pronged test and all that you mentioned, is we could defer the tariff until the next rate case. Would that be a solution that we might consider?
If you didn't change the rates now and you waited until the test year of the next rate case, that would certainly eliminate the problem of creating a regulatory asset liability. Yes, sir.
Right. One thing that I've wondered about is since that, since the tariff isn't really a part of the rate making process, so to speak, could one say that any cost shift, whether it's, as we talked about, it's hard to really prove and quantify a cost shift, but assuming it's minimal, as a matter of public policy, would it be best to wait until the next rate case to implement it?
Well, it would eliminate a lot of problems that we discussed and that Commissioner Thomas has addressed. Whenever you change rates in the middle of, in between rate cases, you're out of whack, in effect. You've sort of made an exception to the regulatory model. The assumption is that when you establish rates in the general rate case, the revenues and expenses and costs will stay in balance throughout the period when those rates are in effect. Now, it doesn't actually happen that way in reality, but the assumption is that the relationship between those elements will remain the same, and therefore you don't adjust rates in between general rate cases, except for riders, fuel riders, and EE riders and DSM riders and those types of things. But otherwise, you don't adjust them in between rate cases. You monitor the revenues and the earnings that the utility receives, and if they receive too many earnings, if the earnings are too great, you bring them in and have a general rate case. If their earnings drop below what is reasonable, it's up to the utility to come in and ask to increase its rates in the next general rate case. But in between rate cases, it's generally not a good idea to be adjusting rates.
Do you think that it would be a violation of Act 62 if the commission chose to defer implementation of the tariff until the next rate case?
I did not, I've read that act, it's been in the last 6 weeks, and so I'm not perhaps as familiar with it as some of the rest of you folks are. I didn't see anything in there that required you to adjust net metering tariff rates within a particular time frame. North Carolina has first cousin statute to Act 62, where it's required to look at a lot of the same aspects that Act 62 requires. And it has a number of deadlines in it. It does not have a deadline for net metering tariffs, but I didn't see a deadline in Act 62 for this. If it's there, I missed it. So it would permit you to delay, I believe.
And I believe, since you mentioned North Carolina, there's going to be a similar net metering tariff process in North Carolina. I think it's pending approval now, this similar kind of settlement. Is that true?
That's correct. In this first cousin bill that I mentioned, the legislature in North Carolina required the commission to take another look at the net metering tariff. And just by way of background, I participated in the proceeding that resulted in the existing net metering tariffs in North Carolina, and I have told my colleagues and other people to watch out, that of all the provisions in this act in North Carolina, that one is one that is likely to generate the most controversy. And just from a personal perspective, I'm glad to see that there is a stipulation that resolves a lot of the issues. I think what probably is going to be presented in North Carolina is the same stipulation that you have before you. And that last proceeding, that was 10 or 12 years ago that I participated in, was not much fun. And to the extent that issues like these can be resolved among at least most of the parties, I think that's a positive step forward.
What would you tell your friends to watch out? What do you watch out for?
Well, you've got the background here. in these proceedings and so many other proceedings, there's this issue out there of climate change. I mean, there are people, you've heard them, I'm sure, by now, who just believe that unless we address climate change and eliminate greenhouse gases and that type of thing, we're creating a great problem for ourselves. And these people are very passionate. The rooftop solar people, the installers are very passionate, obviously so. And it's, I think, witness that you heard, Faruqi, he mentioned the situation in Nevada. I followed that real time. There was a documentary on television. If you haven't seen it, you might go back and YouTube that. I've talked to the chair of the commission in Nevada when all that took place. And these types of proceedings just bring these very emotional filled issues to the fore. And, this case has lots of moving parts, a lot of subjective decisions that have to be made. And it puts a lot of pressure on the regulator to balance all these interests. And to the extent the parties can sit down and work through them, it's a give and take process. NCSEA doesn't like some of the provisions here. I'm sure Duke doesn't like some of the provisions here. That's the way negotiation works. To the extent that with all these moving parts, these people who have to live with it day in and day out can bring to you a stipulation that allows you to bless it or not if you believe it in the public interest. It's a good thing in my opinion.
Well, I know when I was a circuit judge, I always welcomed global settlements for that very reason. I never tried to talk parties out of a settlement because, like you say, they're facts that they're aware of that we not as a fact finder may not be aware of. And it's so complex. There's so many moving parts that honestly, I don't know that a 2-week hearing could do justice to resolve it. Do you agree?
I agree that there are a lot of subject decisions that have to be made here. We haven't even gotten into avoided costs. You're going to have to address that at some point, and that has a role to play here. So yes, you have general rate case considerations, you have net energy metering considerations, you have cost allocation. You have a lot of difficult choices that you need to make here. Yes, sir.
And so I guess that brings me to my final question. That is, do you think that the proposed stipulation of facts is in the best interest of all parties?
I think it is in the best interest of all parties. Yes, sir.
Including all rate makers, all rate payers.
Including all rate payers. I think, of course, you've gotten directions to some extent from the General Assembly, and you've got to pay attention to that. But they have the interest of all the customers in mind. And I think the stipulation has the interest of all the customers in mind. And I think were you to approve this stipulation, it would best serve all the interest of the customers in the state, the elected customers in the state.
Thank you so much for your testimony today. Appreciate it. And Mr. Chairman, I have no further questions. Thank you.
Any more questions
Mr.
for
Chair.
Mr. Finley? Is that Commissioner Thomas?
Yes, sir.
You have the floor, sir.
Thank you. All right, Mr. Finley, you just threw something out there that I hadn't thought about, which I think's definitely a pretty good idea, and that's postpone the timing of this change until the next general rate case. And for some reason or another, I don't have the law in front of me right now, but I thought that there was something in there that said that this needs to be dealt with the end of May or the 1st of June. I don't know where I'm getting that from. Like I said, I don't have the law in front of me, but let's just assume then that this could be postponed until the next general rate case. That I don't think would that upset the terms of the stipulation agreement if we went in that direction. In your opinion, would that upset the agreed upon stipulation?
I don't know that I have an ability to answer that question, Commissioner Thomas, and I didn't bring that idea up to bring it to the next rate case. I think that was Commissioner Irvin's, and I do not know whether the act has a limit on time limit in May to come up with the decision for next meeting. I just don't know the answer to that.
Okay. Thank you, sir.
Thank you, Commissioner Thomas.
Chairman Williams,
Commissioner Caston?
this is not so much a question to Mr. Finley, but I guess a question I have. If I've understood all this correctly, being right now probably the only non-attorney in the room, that if we modify or if there's any change, and I think there's something in the stipulation relative to when it starts and such as that, that if there's any change, then it violates that. Am I correct in that assumption?
Well, what I referenced this on page 20 of my testimony, and I went back and looked at witness Huber's testimony on page 19, lines 20 through 22. He suggests that there's a lot of give and take, as you would expect in this, and if it gets modified to a great extent, it may cause the parties to have to go back to the drawing board and take another look at what they have come up with. That is their testimony. That is not mine.
Thank you.
All right. Any more questions for Commissioner Finley? Commissioner Finley, good to see you again. Last time I saw you, you were speaking at NARUC. I believe it was Washington, D.C. in 2018, so it's been a while.
You have a good memory.
Oh, yeah. My question for you is based on your knowledge and experience as a utility lawyer, or I should say, not necessarily a utility lawyer, but in this field of public utility law and regulation, and as a former commissioner, I'm having trouble understanding the position that the Office of Regulatory Staff has taken in this case. Were you able to listen to my exchange with witness lawyer or witness Horry yesterday?
I was, yes, sir.
Okay. From your knowledge and experience, could you help me understand or give me any insight on why an agency like ORS, who's responsible for representing the public interest, which has been defined many times, and a short, simple definition is to represent the concerns of the using and consuming public, no matter the class, why would they present or propose a solar choice tariff with a zero cost shift, considering all the elements of Act 62?
Well, I hesitate to speak on behalf of the ORS, but I will say that it has been my experience that the public staff in North Carolina, I'm less familiar with the ORS, but I would assume they take a similar position, is that in proceedings such as these, and I think Commissioner Caston is looking at this in this way, all these other people are well represented. They bring their own lawyers to the case, the industrial customers, the commercial customers, the renewable energy folks. And the consumer advocate then tends to try to look out more so for what they believe to be the unrepresented classes, which are the residential customers, some of which can't pay their bill to begin with. Sure, they're responsible for looking after all the customers, but sometimes they step back and say, listen, these other classes are so well represented, let's make sure that we represent the interest of those who are not here represented on their own. And I think what the ORS has done, they have said, we're just going to show you an alternative way to calculate cost of service where, in our opinion, cost shifts are completely eliminated based on the summer coincident peak and leave it up to you to balance that factor in with all the rest. It is a bit of an unusual position, and I think listening to witness Horry yesterday, I think he pretty well conceded that you don't really have a good record here to adopt any rates that they would recommend here. I think he's pretty well. I don't want to speak for him either. He'll have opportunity to speak later. But I think they sort of backed away from the idea that you should actually use that to change the stipulation. That's my view of what I heard. And that's the best I can answer on behalf of the ORS.
Well, it's a fair position to take because now you use the term consumer advocate. We have a consumer advocate, but they did not intervene in this case. So I find it interesting that the position, as I understand it, is to represent those who are not in the room. When the mission requires, from what I understand, to represent all ratepayers. So let me ask you this then: is it dangerous for the commission to not fully consider the zero cost shift proposal when there's such a large gap between what is believed to be the cost shift? Is there a risk, in your opinion, that we may be setting South Carolina up for an outcome similar to what has happened in California?
The answer to that question, Commissioner Chairman Williams, is that I think you've got to consider it in North Carolina again. When you have stipulation before you and you have participants in the case who take issue with that stipulation, you've got to consider the position that is not in accord with the stipulation. If you don't, in North Carolina, you have an opinion that is subject to appeal. You've got to address that. That's evidence in the case. You've got to agree with it or disagree with it as you deem best in your expert opinion. On the other hand, if you find it not persuasive, I don't find it persuasive in this case. And if you find it not persuasive, then you just give the reasons why and stick with the stipulation, which is all the other evidence in the case supports.
Good to see you again, Commissioner Finley. Thank you for your testimony.
Thank you, Chair Williams.
Anything else for Commissioner Casson?
Since I have you here and these things have been going through my head, and Mr. Finley, this is the first time, as far as I know, that you and I have met. Certainly, you are a vast resource, great resource, and I kind of hate to see you go because there's so many questions I'd like to ask you, but I know I can't do that. But through this discourse, what I've been thinking is that, I'm certainly trying to grow in my role as a commissioner and understand to the best of my ability. And being a non-attorney, there's also aspects of that makes that challenging, but I'm glad we have a good staff around to help me in that area. That said, as I understand my role, we are, as a commission, required to make our judgments based on matters of record, correct?
Correct.
And while, I may have thoughts or ideas how I would look at something and, and I know it's not my role to tell any other agency how to do their job, correct?
That's correct, but you sort of do that when you issue opinions. you set the benchmark, and then when they engage in testimony and in negotiation and stipulations, they should have always in the back of their mind, what are these 7 commissioners going to do with what we come up with here? So you're the ultimate arbiter, the ultimate decision maker, and you send signals that they need to pay attention to.
Well, one thing I do think I've learned or understand is this job is not simple or easy, but it would be perhaps easier if we did have someone that would do more of these things, that would look more after the complete customer base, that would not just be so narrowly focused and provide information that we can make wise and prudent judgments on, that consider all the things that really need to be considered. Do you agree?
To the extent that there are interests that are underrepresented before you, it would be an improvement to have those interests represented. Yes, sir.
Thank you so much. I hope to meet you again in the future.
Thank you, Commissioner Caston. It's nice to be here.
Any redirect?
Madam Chair, Vice Chair.
I'm sorry, Commissioner Irvin?
Thank you. You know, I believe that our Act 62 does have a provision that we have to make a decision in this docket by June the 1st of 2021. Now, having said that, I suppose that we have the option to prove the stipulation of facts based on the record, or one could argue that we also have the option to defer implementation of the tariff or NEM until the next rate case, so that we could decide that we could adopt the stipulation of facts, which essentially decide all issues that the parties other than ORS have agreed to, but defer implementation until the next rate case. Does that sound like an option we should consider?
It is certainly something that you're free to look into. As I say again, I was unaware that you have the deadline within the Act 62, so you want to look at what the Act said and talk with your lawyers to, and perhaps ask for opinions from the participating partners, what their view on the legality of that would be.
Right. That would also, I guess, if the parties would agree to that, that would give us the time that we need to do that further analysis that you talked about, the 2-prong test, the looking back at Duke's earnings and comparing that to what we approved in the last rate case. That would give us time to have an expert evaluate all those factors and give us a recommendation, right?
It would give you time to do what you haven't been able to do thus far, correct?
All right. But in your view, is it fair to say that since ORS's own expert witness, Mr. Ori, essentially conceded yesterday that his recommendation did not really meet the standards of a law and did not comport with the Commission's determination as to how to, it did not comport with the rates that are in effect, because it changes that summer peak to winter peak, and that throws everything out of kilter. He conceded that yesterday, as you mentioned. The worst of all options would be to adopt that position. And that would create chaos, wouldn't it? Because now we've upset the apple cart for all the rates that are out there.
I think it would be a bad idea to accept that position, yes, sir.
Thank you very much.
Thank you, Commissioner.
Any more questions from commissioners for this witness? Redirect.
Yes, Mr. Chairman. Just a few questions, Mr. Finley. I want to start with a couple of questions about Commissioner Thomas's questions to you. Would you say that a statutory deadline is a foreseeable event?
Of course, it would be.
And is it your understanding that net metering currently reduces the company's revenue to below what was approved in the most recent rate case?
That's my understanding, yes, ma'am.
Thank you. And from Mr. Huber's answers yesterday, is it your understanding that the Solar Choice Program would decrease those losses somewhat, but not entirely?
That's how I understood witness Huber to testify, yes, ma'am.
So rather than a measure that will increase revenue, is it appropriate to think of the new proposed tariffs as a revenue loss mitigation measure?
That's what I understood the witness's testimony to be, and the answer would be yes.
Now, do you also recall Chairman Williams' question about whether it's dangerous for the commission not to consider ORS's zero cost shift proposal?
Yes.
Is it your understanding that under the commission approved methodology that Duke uses, that the stipulation is a zero cost shift proposal?
Yes.
And you also believe that the stipulation would reduce costs for all customers?
Yes.
Thank you. No further questions, Mr. Chairman.
All right. Chairman Finley, good seeing you again. You may step down from the witness stand.
Thank you, Commissioner.
Attorney Mixon, please call your next witness.
Thank you, Mr. Chairman. SACE, CCL, and Upstate Forever call Eddie Moore to the stand.
Hello.
You know what? I'm sorry. I didn't look at the time. Let's take a brief recess. We'll be back on the record at 10:15. I'm sorry, 10:30. All right, good morning again, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina's hearing and docket numbers 2020-264E and 2020-265E. Let's take roll. Present here in the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioners Thomas, Irvin, Williams, and Powers. We just finished with witness Finley. And it's my understanding that witness Brad Harris is now available. Is that correct?
Commissioner, Chairman, I'm not sure if that's directed to the lawyer or myself, but I'm available.
Okay. Is there any, we have some brief questions for you. Is there any objection to recalling witness Harris at this time?
Mr. Chairman, this is Ashley Cooper. I see Ms. Shirley Smith. I'll defer to her. I don't believe there is, but I certainly would defer to her.
And Mr. Chairman, this is Kate Mixon. We don't have any objection to Mr. Harris testifying now.
We don't have any objection.
All right.
Thank you.
I think this should be fairly quick. Witness Harris, if you would please take the witness stand. And pause to be sworn in. You were excused, so we're going to swear you in again.
Mr. Harris, do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Thank you.
Witness Harris is available for questions from the commissioners.
Thank you, Chairman Williams. This is Commissioner Williams.
You have the floor, ma'am.
Thank you. Witness Harris, thank you for coming back. I really do appreciate this. The commission has heard a lot of numbers over the past 3 days, and I want to take you back to Wednesday when Commissioner Powers was asking you questions. And I think he was asking you about annual bill numbers for Solar Choice NEM customers who when they evolve onto the Solar Choice tariff. I believe you gave a percentage reduction or a percentage increase in their bill. Do you recall what that was? Can you answer that question?
Yes, Commissioner. So just to sort of reiterate, the question that I believe I was referring to was, what is the increase in the bill if you compare today's policy of full retail net metering to the Solar Choice tariffs? And according to the modeling that I've conducted for the companies, or under my supervision, those bills would increase by shy of 80%. So again, just shy of 80%.
That is what I heard you say. Their bills will increase by 80%.
Just shy of it.
Okay. So. Thank you. I appreciate that, and I'm not sure what to ask now. But I appreciate that we were seeking some clarification.
Sure, absolutely.
No further questions, Chairman Williams.
Any more questions for witness Harris from commissioners? Hearing none. Anything else for this witness? All right, witness Harris, you may step down and be excused again. Thank you, sir.
Thank you.
Attorney Mixon, please call your next witness.
Thank you, Mr. Chairman. Say's CCL and Upstate Forever call Eddie Moore to the stand.
Hello.
Mr. Moore, if you would raise your right hand. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you very much.
Would you please state your name for the record?
Eddie Moore.
And by whom are you employed and in what capacity?
I'm the Energy and Climate Program Director for the Coastal Conservation League.
Mr. Moore, did you cause to be pre-filed in this docket on March 8th, 2021, rebuttal testimony consisting of 18 pages and 2 exhibits labeled Exhibit A and Exhibit B?
Yes.
Do you have any changes or corrections to your pre-filed rebuttal testimony?
No.
And if the questions put to you in your testimony were asked of you at the hearing today, would your answers be the same?
Yes.
Were the exhibits to your testimony prepared by you or under your direction?
Yes.
Mr. Chairman, I would move to have Mr. Moore's pre-filed rebuttal testimony entered into the record as though given orally from the stand.
Mr. Moore's pre-filed rebuttal testimony will be entered into the record as if given orally from the stand.
And I would also move to have the 2 exhibits attached to Mr. Moore's pre-filed rebuttal testimony entered into the record and identified as the next composite hearing exhibit.
Mr. Moore's 2 exhibits will be marked as a composite exhibit and entered into the record as hearing Exhibit 17.
Thank you. Mr. Moore, did you prepare a summary of your rebuttal testimony today?
Yes.
Would you please read your summary to the commission?
Yes. Now I'll try to make it brief. I appreciate the opportunity to be here today. The purpose of my rebuttal is to agree with the rebuttal testimonies of Duke Energy witnesses supporting the proposed solar choice program and embodied in the stipulation that's before the commission. I also explain how the ORS witnesses only partially address the requirements of the Energy Freedom Act. As the Duke witnesses testified, the stipulation complies with both the letter and the spirit of Act 62, and it creates a win-win-win situation that works for solar customers, for non-solar customers, and for the utility. This is evidenced by the broad support by nearly all parties to this proceeding, including environmental nonprofits like CCL, North Carolina SEA, and Vote Solar, including representatives of the solar industry, and including the Duke companies. ORS is the only party in these proceedings that opposes the proposed solar choice program, and their opposition results from an incomplete reading of the net metering sections in Act 62 and a failure to address the goals of the Act as a whole. The legislature explicitly sets out its intent in this Act to build upon the successful deployment of solar generating capacity to continue enabling market-driven private investment in distributed energy resources by reducing regulatory and administrative burdens to on-site distributed energy resources. And it required this commission to establish a solar net metering requirements that fairly allocate costs and benefits to eliminate cost shift to the greatest extent practicable. The statute, this has come out today again, but it's true. It doesn't contemplate that eliminating cost shifting and promoting customer-based renewable energy are mutually exclusive goals. Thanks to significant stakeholder discussion and the willingness of all parties to compromise, the proposed solar choice program in this proceeding instead meets these goals. It eliminates the cost shift to the greatest extent practicable while enabling solar customers to reduce peak demand in alignment with the interests of all ratepayers. That's exactly the kind of outcome envisioned by the Act. Act 62 charges both the utility and the commission to do more than merely allow reasonable cost recovery or avoid cost shifting. It requires the development of rates that protect solar customers' rights and enable them to produce meaningful bill savings while serving a broader public good. This is a sophisticated objective. It departs from the status quo approach to rates and rate design, and it requires innovation. Duke's proposed solar choice program meets those objectives. By contrast, ORS has focused its case only on one public interest purpose, which is eliminating cost shifting. And I'll say they pursued that incorrectly. And while all other parties agree that cost shift is eliminated eliminated or substantially reduced under this proposal, ORS derives its own calculation of cost shift by imposing an entirely different cost shift methodology on solar customers. In addition to being discriminatory, that treatment of solar customers as a separate class is contrary to the Act 62 provision, which states that the utility must study the cost to serve solar customers as though they were a distinct class, but for analytical purposes only. Even more fundamentally, they've ignored that the Energy Freedom Act does not require elimination of cost shift at all costs, but rather to the greatest extent practicable on customers who do not have customer-sited generation, while also ensuring access to customer generation options. While ORS is supposed to represent the public interest generally, they focus their case only on one public interest purpose, eliminating cost shifting, and consequently have failed to articulate any option that serves the using and consuming public and satisfies the requirements of Act 62. For those reasons, I recommend that the Commission reject ORS's recommendations in this proceeding and adopt Duke Energy's proposed solar choice program. That concludes the summary of my rebuttal testimony.
Thank you, Mr. Moore. And Mr. Chairman, the witness is now available for cross-examination and questions from the Commission.
North Carolina Sustainable Energy Association.
Thank you, Mr. Chairman. Peter Ledford on behalf of NCSEA. Mr. Moore, how are you doing this morning?
Doing well.
Mr. Moore, are you generally familiar with what has happened in Nevada when that state's Public Service Commission changed net energy metering?
Yes, it caused a very sharp reversal in the solar industry.
And is it true that Nevada at first chose not to grandfather current net metering customers?
That's my understanding.
And subject to check if necessary, would you agree that the three largest solar leasing companies exited Nevada soon after these changes were made?
I would say subject to check. What I know for sure is that leasing was a significant part of the solar market in Nevada, as it is in South Carolina, and that's not a given. In many states, net metering doesn't include leasing, which is an option that allows many customers to adopt solar without upfront costs. So we're similar to Nevada in that sense, and it adds a sensitivity to any settlement that we attempt to reach here.
So I'd like to dig into that distinction between leasing and ownership for just a second. Isn't it true that the leasing model depends on cost savings per month for customers and not on a payback period?
Right. I'm, not a banker, I'm not a finance expert, but the selling point is no money down, as opposed to there are many investment decisions that a person who has the means will make by fronting money, knowing that they'll make money later.
And isn't one of the benefits of solar leasing that it allows customers of low and moderate income to afford solar in South Carolina?
Yes, the common assumption, and this whole debate has evolved forward essentially from circumstances in California. You'll notice so many of the witnesses in both this case and the Dominion case have experience in California. And, historically, solar prices were very high and marginal rates were very high. So all these arguments about cost shift and only the rich do it, they made more sense in that context. We're in an era where the upfront cost is lower. The rates in South Carolina are lower. And the fact that we have leasing means that not only is it possible for people who are not high income to adopt solar, a lot already have.
And so, in your opinion, is the settlement that's before the Commission sufficient for both leasing and sales business models here in South Carolina?
Yes.
And Mr. Moore, do you think that if the Commission were to side with ORS in this case, that solar leasing companies would leave South Carolina?
I think you would get a Nevada result, and I think the way you can confirm that, I think if you look at page 29 of Mr. Horai's direct testimony, he outlines what he says would be an easy way to eliminate the cost shift, and he recommends a tariff. And that tariff, if you wanted to have a law school class on what is an unjust and unreasonable rate, it's that tariff. The minimum bill in South Carolina, in Duke Energy Carolina's territory, would be $52 a month. So if a customer left their home for that whole month and used no electricity, they would start by paying $52 a month. Then they would pay $10 a month for each kilowatt of solar. So many of your solar systems out there, roughly 8 kilowatts, that's $80. Then the energy charges, let's say they are at home and they use some energy. At the times of day that you would most likely use the energy, which is the regular peak, those charges are roughly 26 cents a kilowatt hour. So in other words, more than double what other customers pay when you want to turn on your air conditioner or you want to make breakfast or have a shower. The off-peak rate that's supposed to be the low rate is roughly equal to what everybody else actually pays on average. So there is no low rate under ORS's recommendation. And 20 times a year, these customers could pay 45 cents a kilowatt hour on top of the $52 a month and the $10 per kilowatt. So when the polar vortex hits, or when it's a really hot afternoon and you desperately need to use energy, ORS would have these customers paying 45 cents a kilowatt hour on top of a $52 minimum bill. So, in my view, this is what happens when the supposed Consumer Protection Agency does not look after the interests of all the ratepayers. Like these ratepayers, nobody looked out for them in ORS's proposal.
Thank you, Mr. Moore. I'm going to switch gears and try to share my screen. Mr. Moore, are you able to see this letter to the editor from the Greenville News?
Yes.
Okay, thank you. Mr. Moore, I'll represent to you that this is an op-ed that was written by Representative Jason Elliott, who represents District 222 in the South Carolina House of Representatives, and it was published in the Greenville News on March 13th. Mr. Chairman, I would move that this op-ed be admitted into the record as the next hearing exhibit.
Any objection? All right, hearing no objection, the op-ed will be entered into the record as hearing exhibit 18.
Thank you, Mr. Chairman. Mr. Moore, are you aware that in this op-ed...
Attorney Ledford?
Yes, sir.
Give us a second to distribute the exhibit.
My apologies. Please let me know when I can continue.
All right, please proceed.
Thank you, Mr. Chairman. Mr. Moore, are you aware that in this op-ed, Representative Elliott describes the tariffs proposed by the settling parties in this proceeding as a compromise that benefits all ratepayers?
Yes, I've actually seen that op-ed before. Internal to my organization, we kind of follow the news clips daily, and so I've not studied in detail, but I see that summary.
And are you also aware that in this op-ed, Representative Elliott notes that these tariffs are already being touted as a model for other states?
Yes, because in state after state, there has historically been this kind of never-ending debate over cost shift that's based on an embedded cost theory that I think is not the right way to look at it. But it's interminable, and so it's remarkable, really, to reach an agreement with the utility that starts to move us beyond that and into what I think is a more productive future.
Thank you, Mr. Moore. I'm going to stop sharing. All right. Mr. Moore, do you believe that the stipulation is in the public interest?
Yes.
And why do you believe that it's in the public interest?
It's not just that I think it enables a continuation of the solar market, which I think it does. I think it brings together some policy areas that have developed separately and that need to be integrated. And this is where, I think to some degree we've been lumped in as solar advocates, which we are, but our interests are not entirely overlapping. And it gets to some of the questions that have been raised about who's looking out for all the ratepayers. I'm not going to tell you that the whole purpose of our organization is to look out for all ratepayers or to protect low-income customers, but the principles that we pursued in this settlement are things that we think are important because they are applicable to all ratepayers, not just solar ratepayers. And so I think it's past time that we began to bring together energy efficiency and distributed generation, and this proposal begins to do that. I think it's past time that we attempt to have rate design that sends customers a price signal where their behavior will lower the cost of utility service, and this does that. And to Mr. Huber's point that it was not clear at the outset that this kind of settlement was possible. I shared that view, and the terms of this agreement do reflect a lot of compromise. In my experience, sometimes in the long run, it's good to have a compromise where all parties gave something and got something. It becomes a more durable public policy instrument than a short-term win. So there are a lot of reasons, and those are some of them.
Thank you. And you mentioned the interplay between the time-varying rates and the energy efficiency aspects of the settlement. If the stipulation's rate structure is adopted in this proceeding, but the bring your own thermostat incentive is not adopted in the energy efficiency proceeding, would that structure work for most customers?
It would not work as well, and it misses a key part of the good that we're attempting to do with this settlement. So I think that BYOT and the BYOT program is explicitly a first step. So there are many ways in which demand can be managed beneficially, and using the thermostat technology is one, but explicitly in this memorandum and stipulation, it's not the only one. And we want this to be the first step towards a number of good things. And so it would cut short that beneficial intent if we don't take what I would consider the most obvious positive step towards helping customers manage winter peaks.
Thank you, Mr. Moore. I'd like to switch gears for my last few questions. You were involved in the development and passage of Act 62, correct?
Yes.
And are you familiar with Section F1 that directs the Commission to establish a tariff to go into effect for applications received after May 31st, 2021?
Yes.
And would you agree that Section F3 says that the tariff shall include the methodology for compensating customers for the benefits provided by their rooftop solar?
Yes.
And would you agree that the stipulation that is before the commission includes the such a methodology?
Yes.
Thank you, Mr. Moore. I have no further questions. NCSEA has no further questions.
Solar Energy Industries Association.
Good morning, Mr. Chairman. Solar Energy Industries Association has no questions for this witness, and we thank him for his testimony.
Vote Solar.
Beth Durant for Vote Solar. Vote Solar has no questions. Thank you, Mr. Commissioner.
Alder Energy Systems, LLC.
Taylor Spear appearing for Alder Energy, no questions. Thank you, Mr. Commissioner.
Office of Regulatory Staff.
ORS has no questions for Mr. Moore. Thank you, Mr. Chairman.
Applicant.
We have a few questions, Mr. Chairman.
Please proceed.
Good morning, Mr. Moore. Nice to see you.
Good to see you.
Can you hear me okay?
Yes.
From your involvement in the development of Act 62, do you understand that there is a deadline for the commission to issue a decision such that the tariffs coming out of this proceeding will be available to subscribers on June 1?
Yes.
And were you following the hearing when there was some discussion about whether the commission had the ability to delay deciding the substantive matters in this case?
Yes, and the commission obviously has to make some decision by that deadline. And I would say, I mean, I'll follow your questions on that, but some of the discussion was a little concerning that it may not end up, getting us there.
And you attached the act to your testimony, and Mr. Ledford just asked you a few questions about Section F1 and F2. And in the tariffs that come out of this proceeding that are supposed to be available June 1, does the act require the commission to make decisions on the matters that are at issue in this case, meaning what that successor solar choice tariff looks like? That is what's due by June 1, is that correct?
Yes.
And I'm asking you these questions because of your involvement in Act 62, but this is also a legal issue, is it not?
Yes.
Okay, thank you. And were you following the hearing when there was some discussion about whether the commission had the ability to order a regulatory liability coming out of any solar choice tariffs approved in this case? Did you follow that discussion?
Yes, I feel like the former chairman from North Carolina gave us a great class on regulatory assets.
But there is nothing in Act 62 that permits this type of regulatory liability that was discussed before. Is it your understanding that there's anything in the Act that permits that?
It's not expressly authorized, but I think, maybe, and this point was touched upon before, what he outlined is that if there's an unforeseeable event that, meets some other criteria, then you might create a regulatory asset. And those are not the conditions that we're in right now. We didn't get hit by a storm. The legislature passed an act and set a deadline.
Thank you. And this would also be a matter of law, correct? What the commission's authority is in terms of establishing a regulatory liability in this case. That would be a matter of law too, correct?
Yes.
And while we have had a long 3 days on a lot of factual and policy testimony, the legal arguments in this case come in the form of briefs and proposed orders. Is that correct?
Yes.
And so would you expect that parties will also be briefing the legality of some of the issues in this case in their filings subsequent to the hearing?
Yes, especially it's a matter of first impression or almost first impression. There are other parallel cases.
Okay, great. Thank you. No further questions.
Commissioners, Commissioner Caston.
Good morning, Mr. Moore.
Good morning.
You said a couple of things that stood out to me, and frankly, I agree. But relative to, I think your statement that you, and I think you said your organization, certainly looked to the interest of solar, you also considered and had the interest of others in mind, and I have no doubt about that at all. That's a true statement, correct?
Absolutely.
That said, is it still a possibility at times, whether this is one of those times or not, and certainly understandable, that you can't always, well, you can never be the defense and prosecuting attorney at the same time?
That's right.
So as I think about that, I believe no one can serve two masters, and my only thought relative to that is why I really believe what you said you meant and is true. But I think it would be still good from my perspective, really the commission's perspective, and it is what it is. This stipulation is what it is. I understand that. But it would still be more satisfying, at least more satisfying for me, if there was that entity, that group, that whatever, that totally had the other group, the other customers, the other consuming public in mind. Does that make sense?
I agree, and I feel like I've, in some ways seen that in action in other states. And in our state, the legislature has recently created a consumer affairs office that is perhaps under-resourced, so you don't hear the voices loud. I would also say, if you look across the Southeast, in the nature of people to some degree pitting some ratepayers against others or some interests against others, you're often, I don't think it's because it's Southern, I think it's because the states are more rural and they're smaller urban centers. There's often not a vigorous residential ratepayer advocacy sector. In other words, in the big states, you have ratepayer organizations, even outside of ORS or general staff, that are looking out for ratepayers. And my observation is that often over the last 10 or 15 years, it's been environmental organizations that have articulated the interests of those general ratepayers. And so in Oklahoma, Sierra Club opposed a major new coal plant. That turned out to be a really wise decision as gas prices fell, and it saved ratepayers money. In Louisiana, the environmental organizations opposed a pet coke plant. It would have been an enormous waste of money. In Mississippi, they were the ones fighting the Kemperer plant, the biggest boondoggle that happened in that state. We can't claim credit. It was Sierra Club in South Carolina fighting the overruns at VC Summer. So the interest, I agree with you, it is not our sole purpose, but the way things work out, they often overlap a lot.
I agree, and I have no issues with, I think Mr. Huber said they had the interest of all their rate base. And the other organizations have too, and I'm not doubting that at all. Just simply stating that my preference would be that we do have that other entity, group, or something that is specifically focused on the other group too. and not leaving it up to others that also have a competing interest. And that's a fair statement, correct?
It's a fair statement, although to be clear, we don't have, us, and I'll say this equally of ORS, we don't have a financial stake in this. We may have a stake, but it's not a financial stake.
Understand. And something else you said that I agree with also is in relative to Mr. Huber's statement that there was serious doubt that this could come about. I think you made a statement, something to the extent that meeting or reaching a mutual agreement can sometimes be much better than getting your way, because in the long run, there's just more to gain when all parties are either mutually miserable or mutually happy. Win-win-win when at all possible, if I understood you, is by far the preferred outcome rather than a winner and a loser.
Yes, sir.
Well, look, I'm not going to keep repeating myself. I applaud the efforts. I applaud this method with the suggestions or hope that I have for the future, and I hope all utilities will proceed down a very similar course, because I think this is a very positive way to do things. Thank you, Mr. Moore.
Thank you.
Commissioner, questions for Mr. Moore?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you. Good to see you, Mr. Moore. Can you hear me okay?
Yes, good to see you.
And probably just as importantly, can the court reporter hear me okay? I'll take silence as a good sign.
Not really. Speak a little bit louder.
Okay.
I think it's the air conditioning unit in here. This morning when we talked, it wasn't on.
Okay. Well, y'all just give me the heads up if I'm not talking loudly enough. I'm getting a little closer to the microphone, so I hope that will help as well. Mr. Moore, you talked about, being a member, being a working member or a part of an environmental nonprofit. Do you all have members?
Yes.
Do you know of any effort or any letters that have been written by your members opposing or supporting the stipulation?
I'm sure that there have been members of ours that have written letters. Often people who are members of environmental organizations are members of more than one environmental organization. I'm sure that it's happened. It hasn't been an organized activity that we've pursued because we're interveners in this case.
Well, I'll let you know that as of yesterday, we had no letters opposing or supporting the stipulation or ORS's proposal, which I find pretty stunning given the note that we reconfirmed this morning that that when the current NEM customers are on the solar choice metering tariff, that their bills are going to go up by 80%. To me, that suggests that balance and that win-win-win that you and Mr. Caston were just talking about. I also kind of wanted to put this on the record so that if there are people who want to share their position, we're ready to hear those. But at this point, we have not received any letters. Do you want to add anything?
Well, I think partly also the point that you're focusing on, the 80% bill increase, it highlights the importance of accompanying this part of the settlement with the other opportunities for solar customers to be more efficient. We saw those two things as two parts of a package. So on one, and the give is the solar customers pay significantly more, but they also have some opportunity to reduce their bill otherwise.
Good point. The other thing related to this that I wanted to ask you to clarify, you mentioned in Nevada that they had originally refused to grandfather solar customers. Would you explain what that is? Because that might relate to the answer you just gave me.
So in general, grandfathering means that customers up to a certain date, whatever the grandfathering date is, are allowed to stay under the same rate structure as when they signed up. And so the legislature here has provided that in kind of tranches, with first group being grandfathered until 2025, the next group till 2029. And there are a number of underpinnings, to the grandfathering policy. There's recognizing investment-backed expectations. There's providing some stability in the market for all the market participants. So I don't know if that's enough to answer your question.
Exactly. I wasn't sure if you meant the 2025 and 2029 provisions, but I appreciate that clarification. There has been some discussion this morning about the potential for considering not placing the stipulation in effect until we have a rate increase. And that caused me to look at the interim riders to see if they would help us in this transition. Do the interim riders involve time of use and peak charges?
I'll admit that I'm having a little trouble remembering which pieces are in the interim and which ones aren't. It's intended to provide a transition period, not a lengthy one, that is really accommodating metering and billing infrastructure. One thing I'll say about the interim tariffs, because it's only a small slice in time, it's going to be a small number of customers.
Right. Well, if my notes are correct, and I think that I recall the purpose of the interim period was to get the billing mechanisms in place in order to then have time of use and the peak charges. So I think my notes suggest that that would not be in play. So if we, but I put that in the record for others to be able to clarify later on if necessary. I think that answers my questions. Thank you very much.
Thank you.
Any other questions for Mr. Moore? All right, hearing none, is there any redirect?
Thank you, Mr. Chairman. We have no redirect and would ask that Mr. Moore be excused.
Mr. Moore, you are excused, sir.
Thank you.
And Mr. Chairman, that concludes SAY's CCL in Upstate Forever's case.
All right, ma'am. All right, Office of Regulatory Staff, are you ready to, wait a minute, we're missing someone, yes, Justin. How can I forget Justin? North Carolina Sustainable Energy Association.
Thank you, Mr. Chairman. The North Carolina Sustainable Energy Association and the Solar Energy Industries Association call Mr. Justin Barnes to the stand.
Mr. Barnes, please take the witness stand. I think you've already been sworn, so Attorney Ledford, please proceed.
Thank you, Mr. Chairman. Mr. Barnes, are you the same Justin Barnes that appeared on behalf of NCSEA and SEIA earlier in this proceeding?
I am.
And did you cause to be pre-filed in this docket on March 8th, 2021, rebuttal testimony consisting of 5 pages?
Yes, I did.
Do you have any changes or corrections to your pre-filed rebuttal testimony at this time?
No, I do not.
And if I were to ask you the same questions today, would your answers be the same as given in your testimony?
Yes, they would.
Mr. Chair, at this time, I move that the rebuttal testimony of Mr. Barnes be copied into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Mr. Justin Barnes will be entered into the record as if given orally from the stand.
Mr. Barnes, did you prepare a summary of your rebuttal testimony?
Yes, I did.
And could you read it at this time, please?
Of course. In my rebuttal testimony, I respond to the direct testimony of Office of Regulatory Services witness Ori and the rebuttal testimony offered by the company witnesses. I agree with the company's witnesses that ORS witness Ori's recommendations for modifying the methodology used in the company's cost of service analysis are inappropriate for the same reasons I disagreed with witness Ori's solar customer cost of service evaluation in docket number 2020-229E on Dominion Energy South Carolina's solar choice tariff proposal. More specifically, it is inappropriate and unfair to assess cost of service for all customers under one methodology while using a different methodology specifically for solar customer. Doing so creates a misalignment that distorts the assessment of any purported cost shift, causing it to depart from a reality of how solar customers actually affect non-solar customers within the solar customers' broader rate classes. I also agree, excuse me, I also further agree with witness Finley and Faruqi that there is value in resolving the typically highly adversarial issues surrounding net metering in a settlement. Such a resolution serves to appropriately reflect the legislature's Act 62 objectives of addressing potential cost shifts and avoiding disruption of the customer-sided solar industry. While witness Ori takes no position on the latter objective in making his own recommendations, effectively ignoring it, it is my continued position that the Commission must give substantial weight to all aspects of Act 62 in its consideration of solar choice tariffs in order to fulfill the legislature's intent. This concludes my summary of my rebuttal testimony.
Thank you, Mr. Barnes. Mr. Chairman, Mr. Barnes is available for cross-examination.
Southern Alliance for Clean Energy, South Carolina Coastal Conservation League, and Upstate Forever.
This is Kate Mixon, and we have no questions for Mr. Barnes.
Vote Solar.
No questions.
Alder Energy Systems, LLC.
Taylor Spear for Alder Energy, no questions. Thank you, Mr. Chairman.
Office of Regulatory Staff.
Thank you, Mr. Chairman. ORS says no questions.
Commissioners, questions for this witness? All right, hearing no questions, Mr. Barnes, you can step down.
Thank you.
All right, Office of Regulatory Staff, are you ready to call your first witness?
We are indeed, Mr. Chairman.
I'm sorry, it sounds like I heard some feedback. Or
Mr. Chairman and counsel for ORS, we have a request, and I wanted to make it prior to ORS taking the stand so that Mr. Nelson would have a chance to address this prior to his witnesses taking the stand. We believe there's been a misunderstanding about Mr. Harris's testimony when he was brought back this morning on the 80%. We don't believe that the conversations that occurred after he left the stand were consistent with what he said, so we would respectfully like to bring him back to clarify that 80% so that the commission has a full and complete record. I make this request now because I did not want to impede upon the Office of Regulatory Staff ability to put its witnesses up last from rebuttal. Thank you.
Is there any objection to calling witness Harris again?
No objection from ORS, Mr. Chairman.
All right, witness Harris. And Attorney Smith, would you like to direct the witness, or I don't know?
Yes, sir, please.
Okay. All right.
Yes.
Oh,
Thank you.
I'm sorry. I'm sorry, we need to swear him in again because I excused him. This time, Mr. Harris, you will not be excused.
Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you again.
Mr. Harris, do you recall earlier when you were asked about the 80% that has been discussed in this case this morning?
Yes, I do.
Will current net metering customers see an 80% increase on their bill?
No, they will not.
Can you please provide more context for the 80% that you were discussing, both in terms of current net metering customers and future solar choice offerings as proposed by the company?
Absolutely. So the 80% is a difference between the policies. But again, to clarify, current net metering customers would not experience that pricing, the bill increase. I think it's also important to note that the current net metering policies result in very low bills around $40 a month. And if it would please Commission, I could provide more detailed numbers if we'd like, but it's around $40 a month. And so the increase in the change in the policy increases that to roughly $70 a month, according to my modeling. It's also important to note that we're sending better price signals here. So, for example, I have modeled the grid access fee using using production meter data that reflects current customers, but we're now sending a price signal not to oversize your system. So we expect what we call the solar offset. We expect the systems to be more appropriately sized, which creates better cost-benefit ratios to allow us to those bills to drop below that $70-ish that I'm modeling. But it's because we're sending better price signals that creates benefits so that the cross-subsidization or cost shift issue that we're all concerned about here is the numbers are still accurate for that. So I don't want people to overstate that number because, again, it doesn't apply to current customers, and we're setting better price signals that the goal is to allow customers to lower their bills in a way that lowers the impact on non-participants. And I hope this has helped give some more context and clear this up.
Attorney Smith, you are on mute.
Sorry.
No, you're fine.
I'm back. I'm sorry. We hope this clears things up, and Mr. Harris is available for questions, and we appreciate the parties and the commission indulgence in letting us come back.
All right. Commissioners, questions for Mr. Harris?
Chairman Williams, this is Commissioner Williams.
Go right ahead, Commissioner Williams.
Thank you. And thank you, Mr. Harris. I don't know where you had planned to be today, but we appreciate your being back here again. Did I hear you say that the current NEM customers, the average bill is $40 a month?
The current policy, the average monthly bill is in the order of $40. If you would please, I provide the exact number if you would like in my modeling. So according to the current policy, so I'm not going back and looking at, I've looked at current bills to make sure that this is reasonable, but I'm not pulling this from a billing system. The current policy in DEP is about $43.06. And please keep in mind that this is estimates. This is, I think, very solid modeling, but it's always an estimate. Yeah. And then in DEC, we have two rate schedules that are commonly used. So we have modeled them both. So about 55% of customers, roughly, are on rate schedule RS, which has an average bill of $42.41, according to this modeling. And customers on RE, which is the all-electric rate.
Mr. Harris.
Sorry?
Mr. Harris, if you could do me a favor and slow down and speak up. I I don't know if
Please,
it's
Chairman.
issues on our side, but you're sort of going in and out. And when you go out, you're speaking so quickly that when you come back in, you're like 5 words into your sentence, and we miss those 5 words.
I'm very sorry about that, Chairman.
If you could give that last number for us. Matter of fact,
Sure.
just start over.
Yes, sir. So in Duke Energy Progress, South Carolina, under the current policy, the estimated bill, according to my modeling, is $43.56. If we move to Duke Energy Carolinas, South Carolina, there are 2 rate schedules that are important in Duke Energy Carolinas that are commonly used. Rate Schedule RS and Rate Schedule RE, which Rate Schedule RE is for all electric customers. So under Rate Schedule RS, the model bill is $42.21. And under Rate Schedule RE, it is $38.11.
Commissioner Williams?
Thank you. Witness Harris, did you also say that based on the policy of solar choice metering, you would predict something in the order of $70 a month?
That's correct. And to provide the exact numbers, so in Duke Energy Carolinas, it would be $71.13. And in Duke Energy, it would be $77.89. So, Commissioner, if you're looking at, when I say just shy of 80%, in Duke Energy Progress, if you look at the increase, it's an estimated 79% increase. If you look at Duke Energy Carolinas, there's a little difference between the 2 separate rate schedules. If you take a weighted average, then you get a 77% increase. So in the grand scheme of things, 79%, 77%, I was sort of rounding and saying it's just shy of 80%. Now, I think it's also important to note here, we're sending superior price signals, and we're trying to incorporate new technologies. So I would expect, and I think it's fair to say, I would hope that the actual, and again, when I say increase, I mean the change in the policies. The customer is not experiencing this. I would hope that new customers under Solar Choice would not see bills that high because they have better sized their system and they're responding to the price signals that we're trying to do. And again, I think it's also important to note, this is a very complex model, so there's a decent margin of error here, but I think that this model is insightful, and I hope is useful in your decision making.
Thank you. Would it be fair to say that 75 to 80% increase is the maximum if a customer did not respond to those price signals and reflecting in time of use?
So, Commissioner, I think what I would say is, if we're assuming that customer behavior don't change at all, so and that our production meter sample is perfect, so we're holding everything constant, and also that we have filtered this data to filter out bad data. We've also filtered, if you recall from my testimony from the generic docket, we did not look at net metering customers who had a solar offset of less than 50%, because a lot of those are very undersized systems that we don't think reflect what customers and developers are aiming for. So, this is holding everything consistent, assuming the assumptions which myself and my colleagues that helped me produce this believe are the best estimate to provide this commission with useful and insightful information.
Thank you, Witness Harris. Appreciate your coming back and appreciate the additional information.
Absolutely. It's my pleasure.
No more questions.
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Harris, based on those numbers, the 77, 79, and what is the cost shift in that calculation?
So the numbers that I was just sharing, Commissioner, are looking at the bill, the changes in bill resulting from the changes in policy. When you are looking at cost shift, you're looking at both the change in the bill and the change in the cost to serve. And so the numbers that we've been discussing about the embedded and marginal lenses for cost shift, those reflect the same bill estimates, but we've also added the cost estimates. So I think the numbers most instructive for you are the ones that I've provided about the elimination of the cost shift.
Okay. And the question I think I've asked others is these goals and requirements and the cost shift and the solar choice tariff, is that not compatible under Act 62? Can't we help with both things as proposed by Mr. Huber?
Commissioner, I'm not sure I understand the question, but maybe I'll try to answer it.
I'm not sure I understand the question. Both goals are compatible.
Yeah, Commissioner, I think we're trying to address both. We're trying to increase the benefits and decrease the costs
exactly.
to non-participants. So we're trying to tackle it from both angles. And I think this is one of, if not the most comprehensive settlement to tackle things from both angles.
Thank you. That's all I have.
Any more questions for Witness Harris? Witness Harris, since we have you here, I wanted to know if you compared the difference in price for current NEM customers on ORS's proposed tariff. Did you run those numbers?
Chairman, I have not. I have not.
Well, would it be fair to say that it would be significantly higher than what you just presented, the 80%?
I think that would be fair. I think my recollection, subject to check, was the ORS's suggested prices were on the order of 40 to 70% higher, subject to check.
Okay.
So,
all right.
Presumably, yes.
Thank you, sir. Attorney Smith, anything else for your witness?
No, sir. We appreciate the commission's time and the party's flexibility here. Thank you.
All right. Anyone else have any questions for this witness? All right. Mr. Harris, you can step down. You are not excused, but you can step down.
Thank you.
All right. Excuse me 1 second. All right, we'll be back at, we're taking recess. We'll be back at 11:45. Good afternoon, ladies and gentlemen. Welcome back to the Public Service Commission of South Carolina's hearing and docket numbers 2022-64E and 2022-65E. We're going to take roll. In the hearing room, we have Commissioner Caston, Vice Chair Belzer, and Chairman Williams. Joining us virtually, we have Commissioner Urban, Commissioner Williams, Commissioner Powers, and Commissioner Thomas. All right, ORS, are you ready to proceed?
We are. Thank you, Mr. Chairman. ORS would recall Mr. Robert Lawyer to the stand.
All right. Thank you, Attorney Nelson. Mr. Lawyer, you've already been sworn. Please take the stand and follow the instructions of your attorney.
Mr. Lawyer, are you the same Robert Lawyer that pre-filed 7 pages of rebuttal testimony in these dockets on March the 8th of this year?
Yes.
Do you have any changes, edits, or corrections to your pre-filed rebuttal testimony?
I do not.
And if I asked you the same questions today as those that are presented in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Thank you, Mr. Chair. ORS asks that the pre-filed rebuttal testimony of Mr. Lawyer be read into the record as if given orally from the stand.
The pre-filed rebuttal testimony of Mr. Lawyer will be entered into the record as if given orally from the stand.
Thank you, Mr. Chairman. Mr. Lawyer, did you also file as an attachment to your rebuttal testimony one exhibit marked as RAL-1 consisting of 23 pages?
Yes, I did.
Do you have any changes, edits, or corrections to that exhibit?
I do not.
Thank you, Mr. Chairman. ORS asks that Mr. Lawyer's rebuttal exhibit RAL-1 be marked for identification, entered in the record as the next hearing exhibit.
RAL-1, Mr. Lawyer's rebuttal exhibit will be marked and entered into the record as hearing exhibit 19.
Thank you, Mr. Chairman. Mr. Lawyer, did you prepare a summary of your rebuttal testimony?
I did.
Can you please present it for the commission?
Sure. Good afternoon, Mr. Chairman, members of the commission. The purpose of my rebuttal testimony is to respond to the rebuttal testimony of Duke witnesses Lee Ford, Bradley Harris, and Lon Huber, and to the rebuttal testimony of Edward Finley on behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, and Upstate Forever. My rebuttal testimony focuses on 2 aspects. Number 1, transparency in this commission proceeding, and number 2, ORS's representation of the public interest as defined by South Carolina Code Section 58-4-10B. Regarding transparency, Duke witnesses Ford, Harris, and Huber mischaracterizes ORS's concern about certain binding agreements within the Memorandum of Understanding, or MOU, as, quote, serious allegations, unquote, that, quote, discredit the companies, unquote. To be clear, ORS has not and does not assert or allege that the companies have acted in any manner less than transparent. ORS simply raised concerns for the commission regarding certain language contained in the MOU. Specifically, ORS expressed concern with MOU binding agreement number 1, which states, all parties will support and advocate for the approval of the proposed resolution described in this MOU before media, stakeholders, social media outlets, this commission, Office of Regulatory Staff, North Carolina Commission, and public staff. Clearly, the MOU signatories are obligated to support and advocate for the approval of the MOU, and that none of the MOU signatories have an obligation to represent the public interest as defined in South Carolina Code, Section 58-4-10. ORS is the sole entity in this proceeding tasked with such by the South Carolina General Assembly, and appropriately raised the concern that the MOU signatories may be obligated to provide only testimony most favorable to the stipulation. Further, the MOU was not filed by the companies in conjunction with their application and stipulation. It was filed over a month later by Nexia and Cia on December 4, 2020, attached to a letter of conditional support, in which the letter characterizes the stipulation as, quote, a portion of the necessary approvals that are part of a broader agreement which combines multiple concepts in creating a future for solar choice in South Carolina, unquote. The letter then characterizes the MOU as the more formal expression of an agreement between the stipulating parties. Accordingly, it appears neither the companies, NCSIA nor SIA, have requested the Commission approve the MOU. Second, regarding ORS's representation of the public interest, advocates witness Finley states that ORS is in opposition to the stipulated rates and tariffs sponsored by Duke and supported by the other stipulating parties. ORS maintains that, as proposed, a substantial cost shift will remain with the permanent tariffs, and the interim riders are too generous toward customer generators if the stipulation is approved. Based on ORS witness Ori's analysis, ORS offers recommendations to correctly calculate and eliminate the cost shift in order to provide the Commission with an accurate foundation for determining the company's solar choice metering tariffs. Duke and advocate witnesses also critique ORS in not providing analysis or recommendations regarding all aspects of Section 58-4020A. As stated in my direct testimony, ORS has a statutory duty to represent the public interest as defined by General Assembly or the General Assembly in South Carolina Code, Section 58-4-10. ORS offers the Commission valuable recommendations to quantify the cost shift impacting customers under current NEM tariffs, as well as the cost shift that will result with the approval of the proposed tariffs. ORS's analysis is necessary and fully aligns with ORS's mission in protecting non-participating customers from undue cost burdens shifted from customer generators. Cost shift impacts were important when solar was a nascent industry, and cost shift impacts remain important now as well as going forward. And lastly, should the Commission find the stipulation as proposed meets the requirements of Act 62, ORS recommends the companies be required to track and report annually to the Commission the cost shift based on the avoided costs for solar customer generators subscribing to the interim riders and solar choice metering tariffs as performed for the current NEM tariffs. However, the calculations would incorporate the value of solar as determined in the generic docket number 2019-182E, which will help to inform future updates to solar choice metering tariffs. ORS would also reserve the right to review and make recommendations on all cost shift impacts in any future general rate case proceeding for the companies. This concludes my rebuttal testimony.
Thank you, Mr. Lawyer. I had just a couple questions to follow up on some testimony we heard yesterday. Were you listening to Mr. Huber's testimony yesterday, which characterized settlement discussions in this docket between ORS and Duke?
Yes, I did.
And do you agree with his description of those discussions?
No, I do not.
Could you please explain why?
I think Mr. Huber mischaracterizes ORS's involvement in settlement discussions. I'll reiterate, and I stand by my testimony from yesterday, that ORS did not have any settlement discussions prior to the stipulation being filed and brought to the public.
Thank you. No further questions. Mr. Lawyer is available for questions from opposing counsel or the commissioners.
Southern Alliance for Clean Energy, South Carolina Coastal Conservation League, and Upstate Forever.
Thank you, Mr. Chairman. This is Kate Mixon, and we have no questions for this witness.
North Carolina Sustainable Energy Association.
Thank you, Mr. Chairman. NCSEA does not have any questions.
Solar Energy Industry Association.
Thank you, Mr. Chairman. Solar Energy Industries Association does not have any questions for this witness.
Vote Solar.
Beth Durant for Vote Solar, Mr. Chairman. Vote Solar has no questions.
Alder Energy Systems LLC.
Taylor Spear for Alder Energy, no questions.
Applicant.
Thank you, Mr. Chairman. This is Ashley Cooper on behalf of the applicant. We have just a couple of questions for Mr. Lawyer.
Please proceed.
Thank you, Mr. Chairman. Good afternoon, Mr. Lawyer. My name is Ashley Cooper. How are you doing today?
I'm doing good, Mr. Cooper. How are you?
I'm doing well. Thank you. I just have a couple of questions for you. Mr. Lawyer, I want to follow up on some questions you just mentioned regarding whether the companies publicly disclose the MOU. And you're aware that on September 21st, the companies filed a letter in the docket announcing an agreement regarding the company's planned solar choice filing.
On September 21st, yes, I am aware of that filing.
And further, Mr. Lawyer, you're aware as a part of that filing, the companies attached a news release that explained the proposed agreement or the agreement and planned solar choice filing.
That is correct.
Okay, thank you very much, Mr. Lawyer. Mr. Lawyer, I want to now switch gears. Obviously there's a good bit of discussion on methodologies. On page 7, lines 2 through 4 of your rebuttal. So I'll give you a second if you'd like to turn to that.
I'm sorry, what page did you say, Mr. Cooper?
Page 7. Yes, sir. Lines 2 through 4.
Okay.
Okay. You'll see you note that, quote, the ORS reserves the right to review and make recommendations on all cost shifts in any future general rate case proceeding for the companies. Do you see that?
I do see that. Yes, that's what it says.
Thank you, Mr. Lawyer. So in such a future rate case, would you agree with me that the embedded allocation of hundreds of millions of dollars in generation and transmission costs would be an important part of such a proceeding?
I think those are important in any rate case proceeding.
Thank you. That's fine. I could have said any. I was just building off of your rebuttal. In such a rate case, let's assume the companies do file a rate case. Would the ORS commit to supporting as reasonable the following 3 methodologies for allocating embedded costs? LOLE. Is the ORS prepared to endorse that as a reasonable methodology?
Well, let me just preface this by saying, Mr. Cooper, that I'm not committing to anything at this point. ORS would be more than happy to take into consideration anything that's proposed.
How about yes, Mr. Lawyer.
That's it. Go ahead, Mr. Cooper.
Well, specifically, how about a winter 1 CP? Could the ORS agree to that as reasonable in advance of a future rate case?
That is certainly something we would consider.
Okay, but you're not prepared to commit today that you will use or rely on that today?
Again, I will not commit to anything today. I will look at anything that is proposed at that particular time in any future case. And we will look at all things considered, I would say. That would be one we would consider as well, as the LOLE.
And on page 4 of your rebuttal, I'd like for you to look at lines 18 through 19.
Okay, 18 through 19.
Yes. You noted that ORS findings identified the cost shift to customers as understated, correct?
Correct.
And as part of that,
through the stipulation rates and tariffs, yes.
Thank you. And part of that reason is because that you believe it's understated is because the Duke companies utilized a 1 summer CP allocator, correct?
That is correct.
Okay. And Are you aware that the Duke companies filed a case for adjustments in electric rate schedules and tariffs in dockets 2018-318-E and docket 2018-319-E?
Yes, I am aware of that.
Okay. And are you familiar with Mr. Seaman Wynn?
Yes, I work with Mr. Seaman Wynn.
Okay. Well, I know that sounds a little fair, but I have to establish these things. I see Mr.
I understand.
Well, I want to read with you, and subject to check, I'd like to read you the statement. In docket 2018-318-E on page 4, Mr. Seaman Wynn states, ORS reviewed the company's reasoning and found their use of the summer peak demand to be reasonable in developing the CP allocator for this proceeding. Is that your understanding, subject to check?
Yes, sir.
And subject to check, Mr. Seaman Wynn further clarifies that this allocator was used for the allocation of production and transmission investments to customer classes. Again, subject to check, would you agree with me? That's his statement.
Yes. Yes.
Okay. In docket 2018-319-E on page 5, again, subject to check, would you agree with me that Mr. Seaman Wynn states the methodology, speaking of the one summer CP, methodology provides, quote, a reasonable assessment and allocation of the company's revenues, operating expenses, and rate-based items?
Subject to check, I'll agree with that.
Okay.
For use in that particular proceeding, I certainly don't think that binds or commits how it's used in future proceedings. I think Mr. Michael Seaman Wynn's testimony said that for that particular proceeding, it was proper.
Which is, and I understand, Mr. Lawyer, but as you stated earlier, you'd agree with me that such a proceeding involves hundreds of millions of dollars of generation and transmission costs, correct?
Oh, sure. I'm not disputing that part. Yes.
Thank you, Mr. Lawyer. And Mr. Lawyer, yesterday, witness Horry mentioned a possible disagreement with the company's avoided cost study. Are you aware of that?
I do recollect.
Okay. And Mr. Lawyer, I just want to be clear. Do you recall that ORS first issued data requests of the Duke companies as early as September of 2021?
It's March 2021. Do you mean 2020?
I'm sorry, 2020.
Okay.
Yes.
I just want to make sure.
Yes. So I'll restate the question, Mr. Lawyer.
Okay.
So, and are you aware that ORS issued data requests to the Duke companies regarding solar choice as early as September of 2020?
That sounds about right, Mr. Cooper. Subject to check.
And you're aware that there were follow-up discovery questions issued in early October, as early as October 2nd.
I'll agree with you, subject to check again. I'm not sure the specific dates they were sent, but yes, we sent several data requests.
Thank you, Mr. Lawyer. And for example, I just want to read to you a couple of the questions that were issued in the October 2nd data request. And again, subject to check. Data request 1-1 says that the September 23rd, 2020 stakeholder meeting materials present an estimate of the cost shift associated with the current net energy metering structure with currently sized systems. It is understanding that the cost shift estimate is based on an embedded cost of service study related to that study provide the following. And then there are a number of subheadings. For example, the cost of service study used to determine the costs that would have been allocated to the NEM customers if such customers were a separate class or special class. Again, subject to check, is it your understanding that the ORS submitted data requests on October 2nd with containing questions such as that?
Yes.
And is, again, subject to check, is your understanding that the Duke companies responded to these various data requests?
Yes, they did.
And I believe there was a data request as recent as November issued to the companies, correct?
Yes, I believe there was. Subject to check, of course. Again, I don't remember the dates, but there was many data requests.
And so my point, Mr. Lawyer, is simply this. Mr. Horry testified that he had some disagreement, and this is the first time we heard about this yesterday, about the avoided cost study, saying it would have been helpful to know this information. But ORS had every opportunity to ask any of those questions to the companies. Isn't that correct?
Yes, yeah, and we did ask those.
But I'm saying to the extent that Mr. Horry identified a question called regarding avoided cost study that was not contained in any of those questions, he identified that for the first time on the stand yesterday. That's not the company's fault. That's something that Mr. Horry could have identified and addressed with the company, as the ORS did numerous other issues related to this topic.
I would defer back to Mr. Horry on his analysis and what information he needed at what particular time to do his analysis. I don't know the proper steps, or I'm sorry, not the proper, but the sequence of steps he takes to conduct that analysis. So I would defer you back to him and how he conducted it and what, why, and when he needed certain information.
But would you, that's fair enough, Mr. Lawyer. Would you agree with me, though, that assuming I'm correct, if the companies learned about this issue for the first time yesterday, it'd be very difficult for the companies to work in a collaborative manner to solve this information or help him resolve his questions?
Again, I'll defer you back to Mr. Horry on his analysis and what and when he needed information.
Okay. Thank you. And this is the last couple of questions, Mr. Lawyer. I appreciate your patience, and I'll be very brief.
Oh, sure.
I asked Mr. Horry a few questions yesterday, and he said they would be better addressed with you. And I was just talking about you've been with ORS a while. Sometimes parties just can't reach a settlement and can't reach an agreement. Isn't that correct, Mr. Lawyer?
That is correct.
And it doesn't mean either party was not acting in good faith, or either party was wrong, or either party was bad. Isn't that correct?
That is correct, and ORS has never implied such.
Fair enough. But I wanted to be clear that just because the companies and ORS weren't able to reach a settlement, the two parties were able to talk and discuss matters prior to the MOU being executed and through the establishment of this docket. Isn't that true?
That is true.
Okay. Thank you very much, Mr. Lawyer. I appreciate your time, and I appreciate your answer to my questions and even correcting me on one of the dates. Mr. Dickman, I have nothing further for Mr. Lawyer.
Thank you, Mr. Cooper.
Commissioner questions.
Chair Williams.
Commissioner Caston.
It's afternoon now. Good afternoon, Mr. Lawyer.
It is afternoon. Good afternoon to you.
You had mentioned 58-4-10, and I knew I'd read that at some point in time, but it'd been a while, so I looked it up again. Some of these things are painful reads, by the way, but I did read it.
I'll agree with you on that, yes.
58-4-10B in particular, unless and until it chooses not to participate, the Office of Regulatory Staff must be considered a party of record in all filings. I think I understand that. If ORS chose not to participate in a filing before the Commission, on what information would the Commission have to use to make a judgment?
Not sure I quite understand that question.
Well, let me try to clarify, because
Okay.
As I read that, I was trying to put that in context too. You know, what does that mean? What do I think it means? Well, I think it means what it says. Unless and until it chooses not to participate, the Office of Regulatory Staff must be considered a party of record in all filings. And it's my understanding that as a commissioner, you know, I can only use what's brought before us as a matter of record. Is that correct?
That is correct, yes.
So my question is, if ORS chose not to participate, say in this hearing, if ORS chose not to participate in this hearing or any other filing in the future, on what information would me as a commissioner have to make my judgment on? Use this hearing as an example.
Well, no, we were always going to participate in this hearing. There are certain ones that we have chosen not. We are a party of record. We'll give you that. Let's get that on the table. After that, our level of involvement will depend on what kind of proceeding that actually is or was. Take, for instance, most recent docket that I can recall, even involving Act 62, was the competitive procurement docket. We were a party of record. We didn't provide testimony. We didn't actively participate in that one because it was more to inform this commission of what those programs actually look like or could look like or look like in other jurisdictions, and for you to make a determination whether that would be in the public interest. Now, once you decide whether it is or isn't, and the utility-specific dockets commence, we will be a party to those and participate. Until something's proposed or filed or asked for, I think that's the best case scenario to give you. The information that you would receive would be from the other parties that are wanting to do that or looking to maybe propose something in the future. At that point, ORS would become more actively involved.
Okay. The second part of that, the regulatory staff must represent the public interest of South Carolina before the commission. And it gives the definition of the public interest using consuming public. What does that mean to you? The regulatory staff must represent the public interest of South Carolina, not any other state, but must represent the public interest of South Carolina. Must, what does must mean in your, what's your understanding of must?
Must, we have to. It's mandated that we do it.
I agree. What does represent mean to you?
As it pertains to the customer, we provide a voice for those customers.
You're an advocate?
Advocate's a much stronger word, in my opinion, than represent. I think represent is the proper term.
Well, I know I've and others have used attorneys in the past, and I think it's typically said, I'm represented by attorney so-and-so. My view, when I'm represented by attorney so-and-so, they're looking after my best interest. They're not only my advocate, they're fighting for me. Do you agree with that?
Yes, I would agree with that.
Okay.
All I was trying to differentiate was that advocate is a much stronger word. You're out there actively promoting. I guess I would say it's a much higher magnitude than represent.
Well, unfortunately, I do not have my Black's Law Dictionary that my kind commissioner friend brought me, so I can't look at it.
I don't have one. I've never even seen one. So,
but I believe I understood you to agree that as far as if an attorney's representing you or me or whatever, we view that as meaning it is our advocate. It's someone fighting for me, as someone looking after my best interest.
Okay.
And it talks about the public interest concerns of the using and consuming republic. Does ORS ever reach out to the using and consumer public to help guide the ORS on what those concerns are? I mean, how do you know you're speaking for the consuming public?
We do have a consumer services department that is actively engaged with customers. We have our energy office, which also helps educate and inform customers on many different things. Does ORS, energy office aside, but the regulatory side of the house, which is what I'm on to, I actively go out and talk to customers. No, I do not, but I do engage with them. Miscellaneous, various emails, phone calls, things of that nature. I always accept those calls and emails and answer and provide whatever information I'm capable of. If I don't have the answer, I will definitely and always do find it out for them. So I guess to answer your question, on the regulatory side, no, we're not actively out there doing, but on the other side of the house, yes, we are. We provide a lot of information for customers to make informed decisions, whether it's, brochures of certain events in the community, our websites. We have several of those, solar.gov, energy.sc.gov, just to name a few.
Good. Thank you. You've already, I guess, touched on this, but, witnesses Harris and Huber both stated that they believe ORS was invited to participate in discussions relative to stipulation. Is that true?
I think that's not entirely accurate. We'll restate the question, because the first part I heard, yes, we were invited to discussions. Were they about the actual stipulation? That's the part I do not agree with.
Okay. So witness Harris and Huber, when I asked them, they said yes, in their opinion, ORS was invited to participate in the stipulation. You're saying no, ORS was not invited to participate in the stipulation. Is that correct?
That is correct. We were never presented with a stipulation, but we did have several discussions. Whether down the road that translated into a stipulation, I have no doubt about it, because it did. It's in front of you. However, we were not presented a stipulation.
Why do you suppose those two witnesses would say this on the record?
I do not have an answer to that question. That would be better suited for those two witnesses, Commissioner.
I understand. Do you believe ORS's interpretation of Act 62 requires ORS not to participate in negotiations such as this?
I'm sorry, repeat that?
Do you believe ORS's interpretation of Act 62 requires that ORS not participate in negotiations such as this?
No, I don't think it requires us to or does not require us to. We're always open to discussion. We're always open to negotiations, as I stated yesterday. That is always on the table, and it's always a possibility.
So along those same lines, do you believe ORS's mission requires ORS not to participate in negotiations such as this?
No, I don't think that either. I'll reiterate what I said about Act 62 requiring or not requiring the same thing. Our mission does not preclude us to do it or not to do it. I think as a professional entity, Duke as well, or any other party, that's always on the table. And in good faith, that should be done when it can be done.
So do you believe it can be in the best interest of the consuming and using public to negotiate with competing interests?
Yes, that potential is always there. Could be.
And finally, I think in some answers you had to Attorney Cooper, you said ORS is willing to consider any proposal. I can't remember your exact words, but is that generally correct? ORS is willing to consider other proposals or any proposal or any discussion?
Absolutely. We consider any proposal that's before us. Sure.
So with that in mind, oh, go ahead. Please finish.
Nope. I'm finished. Go ahead, Commissioner.
Well, was the stipulation not proposed?
No, as I stated earlier, stipulation was not presented to us.
All right, so you're saying ORS was very...
It wasn't proposed to ORS. It may have been proposed to somebody else.
Okay.
Obviously it was. It just wasn't to us.
Thank you. You've been very helpful. I appreciate it.
You're very welcome, Commissioner.
Commissioner, questions for this witness? Redirect.
Chairman Williams.
Oh, Commissioner Williams.
I have a few questions. One question for Mr. Lawyer.
Please proceed.
Thank you. Mr. Lawyer, you mentioned the role that your office had regarding consumer affairs. Are you aware of them receiving any calls or letters, or did you all receive any calls or letters from the using and consuming public with regard to this particular docket?
I cannot, excuse me, Commissioner, I cannot speak on behalf of Consumer Affairs. As far as ORS, yes, I personally received calls regarding this docket. I know our Consumer Services Department has received general inquiries regarding this docket, as well as Dominions.
Okay. Any idea, have there been more for Dominion's Solar Choice docket or more for this one? Could you just describe at all that, what the public interest has been in those calls?
I can only speak personally. I'm not sure what the mix was with Consumer Services Department. But I would say that just personally, I've probably received a little bit more for Dominion than I have for Duke.
And the general nature of those calls, concern, more information, frustration?
No, there was, no, they weren't, from a frustration standpoint, they're more for general knowledge, information. What does it actually mean? Yeah.
I understand that
just
part.
General information. Try to get an understanding of what it is that was filed and what does it mean and why. So.
Great. Thank you. I appreciate your answers.
You're very welcome.
Redirect.
ORS has no redirect for this witness, Mr. Chairman.
Mr. Lawyer, you may be excused. Thank you for your testimony.
Thank you, Mr. Chair.
Attorney Nelson, please call your next witness.
Thank you, Mr. Chairman. ORS would recall Mr. Brian Ori to the stand.
Mr. Horry, please take the stand. You're already sworn. Follow the instructions of your attorney.
Thank you, Mr. Chairman. Mr. Horry, are you the same Brian Horry that filed 17 pages of surrebuttal testimony in this docket on March the 8th of this year?
Yes, I am.
And do you have any changes, edits, or corrections to your pre-filed surrebuttal testimony?
Yes, on page 6 of 17.
Go ahead.
Okay. Lines 25 through 26. Please strike the words, the ORS embedded COS analysis using the Winter 1CP meets this objective. If ORS conducted a full embedded COS study using the Winter. The corrected paragraph should now start. Loss of load, expectation, LOLE provides a more accurate representation.
Thank you, Mr. Horry. Is that the only correction that you have to your pre-filed surrebuttal testimony?
Yes, it is.
Okay. And with the exception of that correction that you just provided to us, if I asked you the same questions today as those that are presented in your surrebuttal testimony, would your answers be the same?
Yes, they would.
And Mr. Horry, did you prepare a summary of your surrebuttal testimony?
Yes, I did.
Can you please present it for the commission?
In my surrebuttal testimony, I address 5 topic areas. First, I rebut the statements of Duke witness Faruqi that I have ignored the stipulation put forth by Duke and the solar parties. My surrebuttal highlights the necessity for ORS to examine the cost shift estimates in this docket. I also clarify that I present the ORS zero cost shift rates as an option for the commission to consider if the commission deems that reduction of the cost shift is of primary importance in this docket. Even if not adopted, the zero cost shift tariff provides the commission with an indication of what rates would have had to have been in order to eliminate the embedded cost of service cost shift. Second, I rebut assertions by Duke witnesses Faruqi, Harris, and Huber, and advocates witness Finley, that the company should not or cannot change their method of allocating generation capacity costs in their embedded cost studies. I reiterate how it is important for the evaluation of the cost shift for solar customer generators to reflect how the DEC and DEB needs for generation capacity are driven by winter peaks, and that the failure to recognize this reality leads to an underestimate of the embedded cost of service cost shift. I further show that the evaluation of the embedded cost of service for customer generators in this proceeding does not necessitate the changing of rates for other customers. The explicit direction of the legislation is that the embedded cost analysis should be done for analytical purposes only. This makes it clear that the analysis done in this proceeding should not set any precedents or dictate changes in rates for other customers, other than how those customers would be affected by the ongoing cost shift burden placed upon them by new customer generators. On the topic of the embedded cost of service cost shift, I also rebut witness Hager's assertion that the allocation factors need to be based on the customers that caused the assets to be built. I show that witness Hager is essentially arguing that assets should be vintaged and the allocations never updated, and further show that such a practice would be unreasonable and inconsistent with the goal of fair allocation of costs among current utility customers. Third, I provide additional detail on why Duke's commitment in the MOU to provide a solar incentive of 36 cents per watt DC, on top of the incentives that would be available to any customer participating in the winter BYOT program, would offset the price response benefits of participating customer generators. Fourth, I clarify that the TOU rate netting for interim riders would not require the modification of any existing TOU rate periods, nor require the establishment of TOU rates for schedules that currently have flat rates. And finally, I rebut witness Huber's claims that the cost duration method should be retained because of its accounting for transmission and distribution costs. Because ORS only recommends the use of the LLE allocation method for generation-related costs, the relationship of the cost duration method to T&D is not relevant.
Thank you, Mr. Hoy. Does that conclude the summary of your rebuttal testimony?
Yes, it does.
Thank you, Mr. Chairman. Mr. Hoy is available for questions from opposing counsel or the commission.
Southern Alliance for Clean Energy, South Carolina Coastal Conservation League, and Upstate Forever.
Mr. Chairman, this is Kate Mixon, and we have no further questions for this witness.
North Carolina Sustainable Energy Association.
Thank you, Mr. Chairman. This is Peter Ledford. We do not have any questions for this witness.
Solar Energy Industries Association.
Thank you, Mr. Chairman. This is Jeff Kirkendall, and Solar Energy Industries Association has no questions for this witness.
Vote Solar.
Beth Durant for Vote Solar. No questions for this witness, Mr. Chairman.
Alder Energy Systems, LLC.
Taylor Spear for Alder Energy. Mr. Chairman, we have no questions. Thank you.
Applicant.
Thank you, Mr. Chairman. I'll be very, very brief with this witness. I do have a couple of questions. Good afternoon, Mr. Horry. I introduced myself yesterday, but again, my name is Ashley Cooper, and I represent the Duke companies in this proceeding. During your testimony, both your direct and your rebuttal, you've mentioned a couple of times doing things, hypothetically or for analytical purposes only, correct?
That's correct.
But your rates that you developed, you developed these rates based on such a hypothetical analysis. Is that correct?
Yeah, and I think that's actually the intent of the legislation is look at it as if the solar customer generators were a separate class. So in that sense, the intent is to base it on that hypothetical analysis.
Thank you, Mr. Hort. But if the rates you proposed were adopted by this commission, it would no longer be hypothetical. It would be very much real life rates. Isn't that correct?
Well, I mean, to be clear, it would affect the rates for those solar customer generators, but there wouldn't necessarily need to be a change to the other rate classes. And the point is, when you do an embedded cost study, you're allocating costs among all customer classes. So what we're doing is we're looking at restricting the results of the analysis in this docket to just the solar customer generators and not impacting the rates for all the other hundreds of thousands of customers.
Fair enough. And Witness Horry, the zero cost shift that you identified would be based on the LOLE methodology, correct?
That's correct.
And you're aware that only one jurisdiction has looked at LOLE, but they were not willing to accept that is the sole methodology, but required additional methodology in addition to LOLE, correct?
Yeah, I believe there was information on that in, I believe, Witness Hager's testimony.
Okay. And so, if we, going back to adopting these rates off of these hypothetical studies or based off an LOLE methodology, are you aware, and did you hear Witness Faruqi and Witness Finley during their testimony where they discussed net energy metering rulings being challenged and possibly being overturned or having been overturned in courts? Did you hear both of them testify about that?
I don't remember their testimonies on that issue, but I am aware that has happened.
Okay. Thank you very much, Witness Horry. I have nothing further, Mr. Chairman.
Commissioner, questions for this witness?
Mr. Chairman.
Commissioner Urban.
I have no questions for the witness, but I did want to make a part of the record the document that I asked Mr. Horry to identify when I cross-examined him, I believe it was yesterday. It's a document prepared by his company, Energy Environmental Economics, or VERDIT, titled Alternative Rate Making Mechanisms for Distributed Energy Resources in California. And I cross-examined him based on this January 28th, 2021 white paper that his firm prepared. And I'd like to make that a part of the record. I believe our staff attorney sent out a copy to all parties, so you should have it. I'd just like to mark that in evidence, please, for the record.
Any objections? All right, California Public Utilities Commission, alternative rate making mechanisms for distributed energy resources in California, successive tariff options compliant with AB 327 dated January 28th, 2021 will be marked and entered into the record as hearing Exhibit 20.
Thank you, Mr. Chairman.
All right. Is there anything else before we adjourn?
Mr. Chairman, just one question, please.
Commissioner Powers.
Thank you, Mr. Chairman. Mr. Ori, in your surrebuttal testimony on page 4, the bottom lines 12, 13, you indicate that the commission should give priority of zero cost shift over disruption of solar industry, or that we could make that choice. The statute does not say zero cost shift. It says as is practicable, does it not?
That's correct. So I was just trying to point out that there is this balancing act, and certainly if minimizing to the greatest extent practicable, you want to interpret that as going to zero cost shift, which is, the greatest extent you could do, then this would be the type of tariff that you would have to have in order to achieve that.
And there's no conflict in us giving weight to both of these requirements of the statute, is there?
Certainly there isn't.
Thank you, sir.
Chairman Williams, I'm sorry, I didn't mean to interrupt. Commissioner Powers.
I think he was finished. Commissioner Williams, you have the floor.
Thank you. Hello, Mr. Ori. You may remember that when we were talking yesterday, I asked about average annual bills using the ORS proposed methodology. Were you able to find those calculations?
Yes, I was, Commissioner. So for depth, the monthly bill under a zero cost shift rate would be $128.97 per month.
Okay.
And for deck, it would be $118.70 per month.
Thank you very much. I appreciate your doing that.
Okay. You're very welcome.
All right. Applicant, after I think it was ORS who asked for the stipulations and the MOU to be entered into the record. It's come to my attention that joinders were filed to the MOU, and wanted to know whether or not you wanted those included with the exhibit.
Yes, sir. We would like those included with the exhibit, please.
All right, those will be included. Good. All right, we're adjourned.
Chairman, Mr. Chairman?
Yes.
I'm so sorry. We had the outstanding issue of briefs and proposed orders, I believe. And the Duke companies had 2 additional requests. I think one's been eliminated with closing arguments. Don't think that's necessary, but we had wanted confirmation that there would be a transcript for use in briefs and proposed orders, and I think we need a date for those if I recall correctly.
We are in the process of figuring that out.
Yes, sir.
I think that you'll have an answer by Monday. Is that too late?
No, sir. We just wanted to make sure that we knew what we needed to do.
All right. We'll be in contact.
Thank you.
All right. Thank you. We're adjourned.